This lecture is on the role of the Supreme Court in foreign policy. First, I'm going to talk a little bit about why even lecture about the role of the Supreme Court in foreign policy, given that very little attention is often paid to sort of the role the Supreme Court plays in foreign policy decision making. So first, the Supreme Court in many ways is the ultimate adjudicator of disputes over powers of the president in foreign policy. So as I talked about for the Congress lecture, members of Congress and private citizens often challenge the executive in court over the constitutionality of the president's actions. That is, so essentially the court becomes the ultimate arbiter of these disputes. That is, when someone challenges the constitutionality of the president's actions based on their powers granted in the Constitution, it is the court that ultimately has to decide whether the president's overstepped his or her bounds, and as a result, the court plays an important role in determining sort of the balance of power between particularly the president and Congress in foreign policy. And so this leads to the second point, that is that the court then delineates the foreign policy powers of the two branches. When there are challenges about who has authority over particular areas, particularly when the president is sued, the court rules on these direct powers, and this can either expand or contract presidential power. So the court's important because while it may not influence foreign policy directly, its decisions about the balance of power between the president and Congress in turn influence whose preferences get advantaged in the system. And as a result, as I said, this leads to the third point, that it affects policy indirectly. That is, courts don't directly determine U.S. foreign policy in the same way, for example, they have in domestic policy, but they influence the process by determining which particular branch has greater authority in any particular area. So it's important to sort of look at how they have exercised this power over American foreign policy. So let's start with court cases that have expanded presidential powers. One of the earliest was a case Missouri versus Holland. The substance of this case essentially is a treaty signed by the U.S. And Great Britain over migratory birds. Basically, there are birds that migrate between the U.S. and Great Britain. They're considered to be important by both countries. They were endangered, so the treaty sort of declared them protected. All right. After the treaty was signed, Congress passed enabling legislation, in other words, laws that uphold our treaty commitments that essentially protect these birds. The state of Missouri sued, saying that the Congress doesn't have the authority to regulate birds. And they essentially argued that birds fall under the purview of the states, and so that essentially that the Congress had no authority to regulate promote regulations over birds. Right? And so they essentially argued that the 10th Amendment specifically grants the states sort of domain over policy areas not directly given to the federal government in the Constitution, and as a result, Congress overstepped its bounds by sort of legislating or by making laws that regulate the treatment of birds. All right, now Missouri had some precedent. Over this. So lower courts prior to the treaty being signed had ruled against the federal government. I mean, in other words, previous attempts by the federal government prior to the treaty had been struck down by district courts as being unconstitutional. So the Supreme Court, however, ruled for the federal government, and essentially their argument was that the treaties have the same force as the Constitution. They are the supreme law of the land. So if the law was made under the provision of the treaty, then it is constitutional, right? So in other words, they essentially are arguing that when there are unspecified powers left in the Constitution, that treaties can delineate those unspecified powers. In other words, when things are already specified in the Constitution, right, a treaty cannot reverse those. But when there are things that are sort of left in question, then treaties can clear up sort of these unspecified points in the Constitution. So their point being that migratory birds, while not mentioned in the Constitution, could therefore be clarified by the use of a treaty, and as a result, enabling legislation by the Congress to uphold that treaty obligation was constitutional. The effect of the court case was to sort of place national priorities over state priorities. So one effect if we think about the domestic level, is to sort of reduce the overall sort of power of federalism within the U.S. system. But on the foreign policy level, again, to prioritize national level objectives over state interests, especially when it comes to sort of foreign policy and the application of treaties. Second, and more importantly for what we're discussing, is it strengthened the president. That is, it legitimized using treaties to add to the constitutional framework of the country. In many ways, this tends to reduce the implied powers of the U.S. states and the Congress in general. In other words, the treaty-making process generally requires Congress to pass legislation that fits a particular policy objective that the president pursued through the treaty. And oftentimes it specifies powers that before were unclear, that often gave the states greater authority, checking the president's powers, or allowed Congress legislative authority to handle matters, again, checking presidential powers. But the effect of treaties is to then require Congress to pass legislation that in other words, to uphold our treaty commitments, but that treaty was negotiated by the president, so it often more closely matches presidential preferences to some degree. The second court case that has expanded presidential powers is U.S. versus Curtis Wright. Many have called this the most important case for expanding presidential powers, and we'll talk about that in a minute. The substance of the case has to do with a war in the Chaco region of South America in the 1930s. Congress passed a joint resolution authorizing the president to prohibit arms sales to any nations engaged in that conflict. As acting under that delegation, FDR in May 1934 does prohibit arms sales to any nation prohibiting in the conflict in the Chaco region. November 1935, he revokes that proclamation. So Congress passed a joint resolution giving the president the ability to prohibit arms sales. FDR uses it, and eventually once the war starts to settle down, he revokes that. Now, the Curtis Wright Company was indicted on conspiring to sell arms to Bolivia being one of the combatants in the conflict. And so they sold it during the period in which the ban existed. The company claimed their defense in the case was that that it was an invalid delegation of power from Congress to the executive. Essentially what they were arguing was that the Congress did not have the authority to turn over one of its powers to the president. And so they had some reason to believe that they would win on this argument. One reason was there were a lot of New Deal precedents that the court had overturned consistently. So, for example, a lot of economic New Deal programs had been overturned by the court as invalid delegations of authority from the Congress to the president, where the Congress would sort of pass legislation authorizing the president to set up sort of economic programs in different states, and the courts had sort of ruled that these were often unconstitutional. So Curtis Wright had thought that this sort of same delegation of power would be similarly declared unconstitutional by the court. Also, in district court, this is sort of the precedent the district court used to rule for and favor of Curtis Wright. So the U.S. appealed to the Supreme Court, and here the court makes a key ruling. The Supreme Court rules in favor of the U.S. against Curtis Wright. And the important aspect of this ruling is twofold. First, the court makes a distinction between internal and external affairs. The court says in internal affairs, the government only has the powers enumerated in the Constitution. Therefore, what they sort of said is the delegations of authority that we had ruled unconstitutional were because these were domestic policies being delegated to the president, and therefore they were unconstitutional because the Congress and the president were limited to what's in the Constitution. But the next thing they said was, in external affairs, the U.S. maintains a sovereign powers of any state. So what they basically are arguing is that outside of the United States, the U.S. maintains greater powers than it does inside the United States. And their logic essentially is, the Constitution does not prohibit the U.S. from acting like other states. It just prohibits what the government can do towards its citizens inside the state. And so their argument is that, for example, if the Congress had nothing about war, this would not preclude the U.S. from going to war to defend its interests. And so essentially the first important argument they make is that the government has different powers depending on whether you're considering the internal politics or the external politics. The second sort of major argument they make is that the president is the sole organ of the U.S. in international affairs. So what they're essentially saying is that the president is given some discretion and freedom from sort of statutory restriction in foreign policy. In other words, they argue the president has powers that go beyond the constitutionally delegated powers of the president when it comes to external affairs. And their argument is that because the president is commander-in-chief, chief diplomat, all the things we talked about in the president lecture, that he is what they call the sole organ, or the chief representative of the U.S. in foreign policy, meaning he or she is given greater discretion in terms of acting outside of the United States. And so this is a central argument, as we'll talk about in a minute. So the effect of U.S. v. Curtis Wright is first to create this distinction between government powers internally and externally. And this has often been used by the government to justify policies done externally that it could not do internally. So, for example, surveillance on people outside the United States is often is much less controversial than surveillance within the United States. Similarly, the U.S. has often talked about its powers to conduct particularly searches and particularly in some cases grabbing or getting wanted fugitives outside the United States without cooperation from local officials as being different than what they'd have to do internally. The second effect is to elevate the president as the sole head of the U.S. and to provide justification for the president having greater authority in foreign policy. So the effect of U.S. v. Curtis Wright often has been presidents using U.S. v. Curtis Wright to justify greater authority in foreign policy relative to Congress, relying on this notion that the president is the sole organ or sole head of U.S. foreign policy, and thus has foreign policy powers beyond what the Constitution justifies. And presidents often uses to argue that in disputes between the president and the Congress, that the president, because the president's the sole organ, has greater authority in foreign policy. So U.S. versus Curtis Wright is a very important case because in many ways it lays the groundwork for presidents to justify their dominance in foreign policy because of the role prescribed to them in the Constitution. The next two cases are U.S. v. Vilmot and U.S. v. Pink, and they essentially deal with the same issue, so they're grouped together. The issue at stake is the Litvinov Agreement. Essentially, the Litvinov Agreement was between the U.S. and the Soviet Union, and they dealt with the status of the property of the Tsar. So essentially, after the Russian Revolution, there's a lot of Russian property that's in the United States that belonged to the former leaders, and so the agreement was formed between the U.S. and the Soviet Union about that property. Essentially, the Litvinov Agreement essentially said all that property was to be turned over to the U.S. government. Right now, in both cases, the state of New York, where most of this property was, claimed that the property was in New York, and therefore the U.S. government could not claim it. That is, because the property resided in the state of New York, it belonged to the state of New York and not the federal government. So in both cases, the Supreme Court ruled for the U.S., arguing that the U.S. was able to take possession of the property because it was given to the U.S. under an executive agreement. And essentially, their argument is that the executive agreement acts like a treaty in that it codifies unspecified powers in the Constitution or unspecified issues that might arise about state and federal boundaries. And so essentially they said that because there was an executive agreement, that the normal course in which states would have authority over an issue does not apply. So the effect of this is to essentially elevate executive agreements to the same force as treaties. In other words, here the court is essentially saying executive agreements act in the same way as treaties. And so this has created a lot of controversy in the study of American foreign policy and among policymakers themselves, because there are essentially two arguments. One argument is essentially that executive agreements, that this expansion, this interpretation of executive agreements has allowed presidents to undertake agreements without the Senate. In other words, this has given the president the ability to essentially conclude treaties without approval from the Senate by simply using the executive agreement. And so proponents of this argument look at some basic data. They say if you look at the trend in the percentage of treaties relative to all agreements or the percentage of executive agreements relative to all agreements, you see that the percentage of executive agreements relative to all agreements, that is, executive agreements with treaties, is increasing over time. So as you can see, by 1939, it's about 50%, about even. that star by 1949 is when those two court cases, U.S. v. Belmont, U.S. v. Pink, occurred. And so you can see there you have a jump to 89%. And then subsequently since then, it's been, sort of in the mid 90% in terms of executive agreements to treaties. And so for those who argue that sort of executive agreements are being used as a substitute for treaties, point to this as sort of evidence for that. Now, there are others who argue that this argument's overstated. They essentially argue that executive agreements are not substitutes for treaties, or not being used as substitute for treaties. And essentially, their argument is that executive agreements, if you look at them, essentially are often either sort of require additional congressional legislation to be implemented, or are often stem from existing congressional mandates, or stem from treaty obligations. And so essentially what they argue is that executive agreements really aren't sort of end runs against the treaty-making process. Rather, they're often used to sort of implement parts of treaties, or implement things that Congress has sort of asked the president to do, or given the president the authority to do, or in many ways, even if executive agreement occurs before congressional or treaty action, Congress is often required to sort of provide funding or back up, or sort of provide legislation to actually implement the executive agreement. So a good example of this sort of last case is the 1994, the sort of nuclear agreement between the U.S. and North Korea was an executive agreement. And Congress had to actually implement this agreement. That is, Congress had control over the agreement in the sense that the U.S. part of the deal, which was providing sort of nuclear reactors, which was harder to sort of divert uranium from, had to be, in other words, paid for. So in other words, Congress had to actually implement legislation authorizing funds to build this reactor in North Korea. So there's this debate about this. The point is, there's a debate about the extent to which executive agreements either are providing presidents with authority to sort of circumvent the treaty-making process, while others argue that really executive agreements are just more implementing tools that fit within sort of the mandate that Congress provides, or implementing tools for what treaties are for implementing particular parts of treaties. The next case that expanded presidential powers is INS versus Chadha, or the striking down the legislative veto, something I referred to in the discussion of the Congress lecture. So, just to review, essentially the legislative veto is when Congress delegates authority, but includes a provision allowing them to veto executive actions. Essentially, as I talked about in the Congress lecture, this is where the Congress delegates power to the president to oversee some policy, but maintains some control by putting a provision in legislation that allows either one or both houses of Congress to overturn the decisions made either generally by an executive agency that's tasked with implementing whatever Congress has delegated. But sometimes it can deal with actual presidential actions, as we talked about with the War Powers Resolution. So in this case, this involved the INS. So essentially the delegation of authority was over immigration. That is, Congress had delegated authority over immigration policy towards the INS. And so what had happened was Chadha had overstayed a student visa. He was picked up by the INS, and so before being deported, Chadha appealed to the courts, suggesting that he should have a hearing. He asked for a hearing to not be deported. The INS suspended the deportation and withheld him essentially until the hearing could be arranged. Okay, so the court, however, had within its delegation, through the immigration laws, a clause that allowed them, through the act of one house of Congress, to deny the stay of deportation of illegal aliens. That is, essentially, they had a clause that said individuals being detained in lieu of being deported, being detained for a possible hearing in lieu of being deported, they could reverse that and just deport them. And this is essentially what Congress ordered. Congress ordered the deportation through this legislative veto of the INS's policies. So Chadha sued, suggesting that the Congress didn't have the authority to deport him, and that they had delegated their authority to the INS, and that the legislative veto was sort of unconstitutional. The court ruled the legislative veto unconstitutional on two grounds. The first, and sort of more trivial reason, was not trivial in the sense of influencing presidential powers, was the notion of bicameralism. So this is sort of straight from the sort of you can think about civics lessons, right? That is, we think the reason we have two chambers or two two chambers of Congress is, sort of this debate about large states versus small states, but the general logic is that bills have to pass through both houses of Congress before they become law. And so the court essentially argued that the action taken against Chadha, or the action taken against those being detained, was only through one house, or through one chamber, and not through both chambers. Therefore, it violated the notion of bicameralism, that is, both chambers agreeing on on something before it actually becomes implemented. The second and sort of more important ruling is the presentment clause. That is the argument that essentially that bills have to be presented to the president before they can become law. And essentially here the court is suggesting that for the legislative veto to work, for Congress to pass essentially pass a revoking of an action taken by the president or an executive agency, they essentially had to follow the standard procedure for passing any bill. Right, so it had to go through both chambers, and it had to be presented to the president, in which case the president could veto the action if the president so chose, and if it vetoed, the Congress would have to then override the veto. Right, and so here this becomes a bigger burden, because this means then that the president has the opportunity to essentially veto the legislative veto, and here the Congress needs to have sort of a veto-proof legislative veto in order to use it. So again, as I talked about before, to think about Congress is not a sort of monolithic organization, right? It's composed of different parties, and within each party, you have people who have different preferences across parties, and so this really put a damper on the ability for Congress to use the legislative veto to check delegations of authority. And so the effect of this, now, and there are two exceptions, obviously. One exception to this presentment clause is impeachment. That is, the president doesn't have the opportunity to sort of veto his or her own impeachment, and presidential nominations. That is, the president doesn't get a chance to sort of use his or her constitutionally prescribed powers to sort of to deal with the sort of support or the acceptance of presidential nominees. The effect of this was twofold. One was it removed one congressional check on the delegation of authority. That is, Congress oftentimes delegates authority because it's more efficient for an executive agency or for the president to handle a matter than for Congress to constantly have to legislate it from year to year. Right? So particularly, immigration is a good example where you have the INS handle day-to-day affairs of immigration policy through a delegation of an immigration law. And so the problem for Congress now is it removes a check that they can use to prevent policies undertaken by the executive that may or may not fit with this particular delegation of authority, right? And so, in particular, for example, the War Powers Resolution is a good example where Congress, wants the president to be able to be flexible and use military force when necessary without having to constantly go to Congress, but they also want to retain some ability to control that use of force. And so the problem is now it puts Congress in the corner of either delegating and providing flexibility, or not delegating and potentially obstructing the application of U.S. foreign policy when they might prefer the president's act immediately. And second, and more symbolically, is that it happened at a time when Congress is trying to reassert itself in foreign policy. That is, INS versus Chadha happens at a time when the Congress is starting to really try to reassert its influence in terms of foreign policy. And so striking down the legislative veto, and a tool that the Congress could use to handle, to challenge the president over particular policies getting struck down, sort of really create a symbolic roadblock to Congress's attempt to sort of reassert itself in foreign policy. Now let's turn to a couple of court cases that limited the powers of the executive. The first is Youngstown Sheet and Tube versus Sawyer. And essentially the background of this case is in 1952 during the Korean War. Right? While the U.S. is fighting in the Korean War, there is an imminent steel mill strike within the United States. That is, there's labor disputes between owners of steel mills and workers, and so there's a real possibility of a strike. And so this is very worrisome for Truman, because the U.S. needs steel mills to be open to maintain the production of military goods, and so not having these steel mills shut down really potentially weakens America's war effort. So Truman, through his Secretary of Commerce, Sawyer, they take over the operation of the mills. That is, Truman essentially claims that for national security, in other words, to maintain this war effort, the federal government has to essentially take over the operation of the mills to prevent their closure. Now, Truman, so the various the various steel mill companies like Youngstown Sheet and Tube sue, and they essentially win. That is, the court rules against the president. And essentially, here you have a very straightforward opinion. Essentially, the court says the president lacked any statutory or authorization to sort of seize the property of the steel mills. And what they meant by that was the president did not have, there was no law passed allowing the president to sort of seize the steel mills. That is, there was no sort of legal authority given by, obviously not given by the Constitution, and particularly in this case, not given by Congress for the president to exercise this power. And so the courts essentially were interpreting that unlike in sort of actions outside the United States, within the United States, right, the president cannot sort of circumvent traditional legal mechanisms for policymaking. And so the effect of Youngstown Sheet and Tube, and so we'll go back to the effect. So there was also a concurring opinion which tried to sort of more to clarify when presidents were more or less powerful in terms of foreign policy. And so here, one justice is trying to really, in some ways, you could say, provide some clarification of when the president is more powerful and some limits on presidential power. And so this is a concurring opinion that's often cited when attempts are made to limit presidential powers in foreign policy. And so this one justice argued the president is at his or her strongest when acting with congressional authorization. That is, when Congress has authorized some use of force or authorized some action, that's when presidential foreign policy powers are at their highest. There is sort of a middle ground when Congress is silent on the issue and the president is sort of relying on his or her own powers to act on some crisis. And third, the president is at his or her weakest when acting against the will of Congress. And so here, again, the idea is that Congress can provide some important check on foreign policy powers of the president, and suggesting that presidents have the least authority or the shakiest authority to undertake foreign policy actions when in conflict with Congress over what to do in that particular policy. Now, the effect of Youngstown Sheet and Tube versus Sawyer has actually been somewhat limited, right? The effect really is to sort of limit the domestic expansion of presidential foreign policy powers. That is, it's really just to sort of say, look, presidents, while they may have expansive foreign policy powers outside the United States, within the United States, these powers don't carry through. That is, to sort of reinforce this notion that there is this difference between internal and external powers of the president, and that even if externally there is something going on, presidents cannot always just justify increases in internal power based on external situations. And so the result is, no real big change in the balance of presidential and congressional powers in terms of foreign policy, but rather it's sort of reasserted that in terms of domestic policy, justifying domestic policy on the basis of foreign policy was not quite the same as the president's powers in foreign policy more generally. The second set of cases are the New York Times versus the U.S., the U.S. versus Nixon, the U.S. versus the New York Times versus U.S. is more famously known as the Pentagon Papers. And so in this case, essentially what you have is the New York Times had gotten a hold of several volumes chronicling U.S. involvement in Southeast Asia, particularly Vietnam. These were volumes from the Defense Department chronicling U.S. involvement. The government essentially did not want the New York Times to publish these papers about American involvement. U.S. v. Nixon are tapes about Watergate. This is sort of a very famous case, right? That is, these are sort of the famous Watergate tapes where the Congress essentially is asking Nixon for these tapes to be turned over. Nixon is claiming executive privilege and claiming on the grounds of national security that there might be discussions about national security, and as a result, that he should not have to turn over these tapes. Now, in both of these cases, the courts ruled against, in the U.S., in New York Times versus U.S., and against Nixon in U.S. versus Nixon. And essentially, in New York Times versus U.S., the court ruled that the First Amendment sort of prevails against this idea of national security, in the sense that while the government does not have to turn over information to journalists, it cannot prevent journalists from printing information they got from their own sources, right? So the idea is that national security, again, has limits in terms of how it applies domestically. Same thing in U.S. versus Nixon. Essentially here, the court essentially ruled that Nixon had to turn over the tapes and that national security did not sort of trump a domestic rule of law, that Nixon, as president, still had to sort of abide by the general rule of law, and that national security was not a basis by which to circumvent those processes. Again, the effective then was sort of minimal limits on absolute presidential authority, or the idea that presidents are not sort of monarchs. Right? So the idea here is that, again, presidents cannot do whatever they want domestically, justifying it on the grounds of foreign policy. But again, the point here is that it doesn't limit what the president can do outside the United States, especially relative to Congress. All right, there's a third type of ruling that we're going to talk about. So the first two are rulings that support the president. The second were rulings that limit the president. There's a third category of what we call non-rulings. Generally, non-rulings help the president in the sense that usually cases come before the Supreme Court. They're challenging presidential action. As the president undertakes an act, a court case comes up and says, what the president did was unconstitutional. We'd like you to stop the president from continuing this act. And so non-rulings essentially are the court saying, we won't rule on this, and it helps the president because that means that there is no legal basis to challenge or to stop the president from undertaking their actions, right? So in other words, it would require a political action or an action undertaken by Congress using its powers to challenge the president. So there's sort of three justifications the court uses to not rule. The first is the political question doctrine. Essentially here the court argues that the issue in the case is a political and not a legal or constitutional question. And what they mean by that is that they argue that the dispute between the parties is not over a legal matter, right, or a constitutional matter. Rather, the dispute is a political matter and something the court will not rule on. So some examples of this. Goldwater versus Carter, as we talked about. This case arises when, as we talked about, Carter essentially breaks the 1954 Taiwan Treaty with Taiwan when the U.S. normalizes relations with China. Members in the Senate sue Carter, saying that Carter needed a two-thirds majority in order to break the treaty with Taiwan. Now, the court essentially ruled that this was a political question. That is, the question of whether we should break the treaty with Taiwan or not was really a political debate and not an issue of law. There was no legal or constitutional question at hand here. Rather, it was a political question about our relationship with China and our relationship with Taiwan. Now, some have argued, why does the court use the political question doctrine? In other words, there are times when political questions and legal questions are very similar. And so they argue, why does the court avoid ruling in these political situations? And some argued that, one, the court perceives it lacks the authority to rule on questions of foreign policy. That is, they argue domestically, we see the courts oftentimes ruling in very political issues. For example, desegregation was a very political issue the court ruled on and issued policies on. And they argue, but in foreign policy, some have argued the court views its expertise as being less than in domestic policy, and so they're less willing to sort of try and influence the political process for foreign policy. Second, some argue that even legal solutions would involve political remedies that would favor one side or the other, and they argue this might create some potential for perceived bias in the court, which might weaken the court's legitimacy. That is, they argue the court's concern about its legitimacy to the public means that it wants to avoid favoring one side and being saddled with favoring a particular foreign policy itself. And third, and similarly, some argue the court just wants to avoid the question. Again, this goes back to the first 2 points. The court's self-perception of a lack of authority and the desire to avoid being sucked into a political debate which might jeopardize legitimacy means the courts often want to avoid foreign policy questions where the constitutional issues are oftentimes very unclear given the overlapping constitutional powers of the President and the Congress. Another way in which the court avoids ruling is what's called ripeness. Essentially, the court, in this doctrine, the court argues the issue or the conflict is not yet ripe. And what they mean is that there is no real conflict over the issue. That is, there is no real serious conflict that requires the court to rule. Right? In other words, often they argue this means that what you want them to rule is on a hypothetical, and that until there's an actual legal or constitutional dispute that's arisen from an action by both sides, that it's not really an issue the court needs to rule on. So to give you an example of this, if you as just an individual wanted to challenge the death penalty, right? the court will probably rule it's not ripe because you don't face the sanctions of the death penalty. That is, it's not an issue that needs to be decided, right? Conversely, someone on death row, it would be ripe for them because they are facing they actually are facing being executed. So for them, the issue whether the death penalty is constitutional or not is a very ripe issue. So, two more examples of this. Goldwater versus Carter it was a ripe issue because the Senate had not taken any action to challenge the violation of the treaty. That is, the Senate had not voted on the treaty. The Senate had not done anything. And so the court essentially said, there is no issue here. That is, you have not challenged the president. There is no dispute between you and the president, except for some people think the president may not have these powers. But there's no dispute that's actually going on. Similarly, Dellums versus Bush. In this is a case where Dellums, a member of Congress, sues to stop Bush in 1990 from going to war in Iraq. Now, this is before Bush sought the authorization to use military force. And so this is essentially the argument that the courts make. They essentially say, Congress has not made any ruling about the use of military force. And so they argue the issue is not right. They sort of argue until Congress actually challenges the president and the president decides to use force in contravention of what the Congress has ruled, there is no actual legal dispute that has arisen. The third sort of principle, or the third way the courts avoid ruling, is sort of the opposite of ripeness, and that's mootness. Essentially, here the court rules the controversy that's being decided is over. Right, essentially, they argue there is no longer a need for a legal interpretation because the crisis or issue that previously needed ruling is no longer exists. A good example of this is in the first Gulf War. In the first Gulf War, there was extreme limits on media coverage. Right, there was concern about that media coverage that had gone in Vietnam might have weakened U.S. morale for the war effort, and so the lesson was in the first Gulf War to place strict controls on media access to the battlefield. The media went along with this during the war, but once the war was over, the media sued the government, arguing that those press restrictions violated the First Amendment. But by the time the media outlets sued, those restrictions had been lifted because the war was over. And so the court ruled that the issue was moot. That is, the restrictions that were the basis for the case no longer existed, so it was a moot point, and so they would not rule on the case because the issue was now moot. And so those are sort of the three bases by which courts avoid ruling on issues. And like I said, these generally tend to favor the president because usually the issues that are brought before the court are challenging presidential actions.